telephone calls or not. Neither Mr. Means nor Mr. Wood state that those warnings were given. So I don't know that. And then I'm left with Mr. Means' argument that he speculates, and his gut tells him that he's being recorded in his phone calls between him and Ms. Daybell. And of course, that is not something that I can act on, nor would Ms. Daybell want me to act on speculation or on gut responses. We have courts of law because we have to act on only the evidence that's in front of us. And that is a task that I take very seriously. And that, frankly, I think I'm very capable of discerning the difference between argument and evidence, as I have frequently told attorneys in my courtroom before. I know the difference between somebody throwing out allegations or making accusations one way or another and understanding that there is no evidence to support those. So I'm well aware of that difference. And then I also have the Madison County Lieutenant's affidavits that were filed. And I understand Mr. Means' objections to those because of the late filing. But I will also say that I don't see any real inconsistencies between those jail affidavits and what Mr. Means stated. They expanded on Mr. Means' allegations, but I don't really see any inconsistencies. I know there have been some allegations between Mr. Means and Mr. Wood. None of those, I think, can be, I guess what I should say is all of those can be explained by reference to both affidavits. I don't think that the allegations they're making towards each other are necessarily inconsistent. I think that they're consistent, just one, Mr. Means' allegations are broader, Mr. Wood's are more specific, and so I don't see a huge amount of inconsistency between the affidavits. I've heard nothing to indicate to me that Ms. Daybell is being treated differently than anyone else at Bonneville County Jail. I do recognize the difficulty that the jails are operating under. I am very aware of how that may impact the constitutional rights of defendants, and that is something that I can tell you all the judges in the state are very aware of. But in this case, I really don't see an impact on Ms. Daybell's constitutional rights with the jail process. The sheer volume of the evidence that needs to be digested by Ms. Daybell and her attorney does make it difficult with her being in jail, but there are other people in jail right now that have defenses that they need to go through with their attorney, certainly none with the volume of this one, I'm sure, but they are still there. There was not any bulk release of defendants from incarceration at Madison County Jail because of the virus. And so I'm confident that that can be worked around. I would certainly invite evidence that conversations are being inappropriately recorded between counsel and client of any sort, whether it's Ms. Daybell or anyone else, to be brought to the court's attention. I'm not sure a motion to reduce bond is exactly the way to do that, but certainly we don't want that happening, and I'm confident that the jail will make sure that that doesn't happen. I happen to believe that Mr. Wood and Madison County Sheriff's Office have great motivation to make sure they don't do that in this case or any other, because it is a serious violation of constitutional rights. And if it actually has occurred, as Mr. Means speculates that it might, and by and I guess what I should say when I say that if it's actually occurring, what I mean is if conversations between an attorney and client without a warning that they're being recorded are actually being recorded, then that would certainly be something that I would want to know about. But I don't really have any evidence that that is actually what is going on here. So on that basis, I'm denying the motion for bond reduction because I cannot find any good cause to reduce bond further than it already has. And I would invite Mr. Means to consult with local defense attorneys who I'm sure have come up with alternatives during this time, and then also have a long track record of dealing with Madison County Jail. I'm aware that different jails can have very different procedures, and I'm confident that there are a number of defense counsel in Madison County that would be willing to talk to Mr. Means about ways to surmount any virus problems at the jail in regards to communicating with clients. Do you have any questions for me, Mr. Means?
I do, Your Honor. You referenced, you made the statement you're confident you could work around, the limitations with the COVID-19 issue in communication with my client. I've had some ideas on that, and I think it would probably help Mr. Wood and I to get some input from you. If you're comfortable in giving us some suggestions, I could possibly make some suggestions to you. You could tell me if those are unrealistic or realistic in your eyes or something that we should consider. It would help us in probably coming to an agreement on how to make that happen.
I never made quarters
Sure.
for the jail because I don't know their procedures well enough. So if the two of you want to talk to me about that and any problems that still persist, which I also haven't heard anything about, but if you want to bring that to me, that's fine. But I always make sure I include the jail in that,
Yes.
because what I know is that what I see from this side of the bench and my understanding from this side of the bench of what the jail does is not always consistent with what they are actually doing in practice. And I only have a small piece of understanding of what they're actually doing. There's a lot to running a jail that I don't get involved in.
Sure. I guess what I'm trying to avoid is in the event that we can't come to an agreement on how to allow communication between the two of us, I don't want to get in a situation where a motion has to be filed and it's pushed out and it's pushed out and pushed out because of what we're dealing with, just because of what we've already dealt with in the future. So again, if you had any suggestions, I'm open to listen. I've got a few suggestions, but again, I can talk to Rob, see if we can come to an agreement. If not, it's probably something that we'd have to bring back to you at some point in time to get some kind of direction or order.
And I guess if you did bring such motion, I would want it very specific as to what you would like the jail to do, because that's the only way they can really respond.
Mm-hmm.
I mean, I'm a great problem solver, I will say so myself, but I can't do it if I don't have the appropriate data, and I do not have the appropriate information about Madison County Jail to make any sort of decision about how things should go.
Sure.
So if any such motion is brought to me, I'd appreciate if it was after you had already attempted to work with them and with specific ideas about what you wanted to do.
Would that be a motion that you would consider that if there's not a request for an oral argument that Rob and I, again, if we can't come to an agreement, which I think we can, that we could submit to you and then you could issue an order on your own without an oral argument?
I'm always open to that. I appreciate if you let me know that's what you'd like to do.
Sure.
And if you'd like to file that under seal, that's fine too, because I know you may not want everyone to know exactly how you're communicating with your client. That may not be the extent of detail that you want everyone in the world to know.
Right.
So you can go ahead and file that under seal on it with a separate motion.
Okay.
So if you'd like to do that, you can do it that way, but otherwise it's hard for me to rule if I don't have specific
No,
information.
that makes a lot of sense, because we would obviously want some protections if some kind of electronic devices were provided to my client that aren't going to be subject to any kind of subpoena or forensic examination at a later time. Those are things that obviously we would want to discuss ahead of time.
All right, thank you. Any questions, Mr. Wood, about my decision?
No, Your Honor.
Can you prepare the order for me, Mr. Wood?
Yes.
And when do you think you can have that for me? It
Does
doesn't-
Monday morning suffice? Or do you need it
Yeah,
before?
Monday by 5 is fine.
You are leaving up to the idea that if I get an opportunity to see the order and sign off as far as a stipulation prior to it being signed by the court?
That's fine.
Okay.
And if there's any problems with that, because of problems with council connecting, what I usually do is just ask the person preparing the order to submit that to me with a letter saying, I wasn't able to get counsel, here's the order. All right. I appreciate your arguments, and we will be in recess.
Thank you, Your Honor.
All right.
Is she across the street? Okay, okay, so I don't.